Now we're going to hear from Newsom's guy, the state of California, asking for Trump's National Guard authority to be checked by this 3-judge panel of the Ninth Circuit Court of Appeals.
Mr. Herbert.
Good morning, Your Honors, and may it please the court. In granting a stay pending appeal, the court recognized a need for judicial review, but did not engage in a detailed parsing of the statutory text at that preliminary phase of proceedings. This appeal provides an opportunity for the court to reaffirm its justiciability analysis and to clarify the scope of limits under Section 12406, including by addressing defendant's extraordinary argument that there is no time limit whatsoever on the scope of a federalization under the statute. As to justiciability, the court was absolutely right in its stay order to recognize a need for judicial review to ensure that defendants' actions comport with the limited authority provided by Congress pursuant to its Article 1 Militia Clause power to commandeer state National Guard personnel for federal service. In the evolving circumstances over the past 4 months.
So let me contextualize this. Newsom, just a week or so ago, asked this Court of Appeals panel, which had stayed the trial court's TRO, stopping Trump, asked this Court of Appeals panel to issue another TRO, stopping Trump's deployment of the National Guard, on the grounds that he has had the National Guard deployed too long. That the time, even if calling out the National Guard was appropriate at the start, it's no longer appropriate. So that's part of the argument this guy's making here.
Only highlight the importance of a judicial.
When he talks about the temporal limits under 12406, which the statute doesn't have a temporal limit.
We'll check in this area. Defendants have expanded their deployments well beyond Los Angeles. They've repeatedly extended the federalization of California's National Guard from 60 days to 150 days, and as of last week, 238 days. They've promised more of the same to come in ensuing weeks in other communities in this circuit and across the country.
Do you have any reason? Do you have any reason to doubt?
This guy, I mean, I know I'm old, but this lawyer for California seems very subdued, very young. He seems frankly out of his depth. Like he took daddy's suit out of the closet and walked into this courtroom, doesn't he? Very low energy, like the kind of person where you have to tell him, "Hey, son, look a man in the eye when you shake his hands." Right? I'm going to rewind just a little bit so we can hear some of that demeanor again.
As of California's Los Angeles, they've repeatedly extended the federalization of California's National Guard.
I mean, he looks like a guy he's not willing to fight, right? The men in the audience, we've all had this experience, right? You can kind of tell by looking at someone that they really don't want to fight. It's like when a dog does it, he rolls on his back and puts his tail between his legs and his paws up, right? A very submissive position. That's the demeanor. That's the vibe I get from this guy, which is, by the way, not what you want in a lawyer.
From 60 days to 150 days, and as of last week, 238 days. They've promised more of the same to come in ensuing weeks in other communities in this circuit and across the country.
Do you have any reason? Do you have any reason to doubt your friend's representation that we're talking about 400 now?
About 400 California National Guard troops.
Yes.
Our understanding is that it's 300. That there were 300.
I'm sorry if I misquoted your friend.
That's correct. And our understanding is that 215 have.
Someone in the comments says it looks like he got voluntold. Super goober. He probably got voluntold. I mean, okay, I got to be honest. If you're going to take the job and you know this is one of the tasks to which you could be assigned, you should not take that job if you're not a fighter. You know, I wouldn't join an MMA gym if I wasn't planning on getting in the ring. I just wouldn't join the gym. It would be a poor fit.
Been sent out of state, hundreds of miles away, many to Portland.
I just think if I were a criminal defendant, right, and I was being charged with crimes that were good for 10 or 20 years in a jail, in a prison, in a cage, and my lawyer presented like this, I would be extremely disappointed. I would be like, what am I paying for?
To Chicago, that there are about 85 remaining in Los Angeles, which we think underscores the point we've raised in our pending motion to vacate before the court, that there is no longer the same pressing need that defendants identified in June that would support continuing stay pending appeal.
What do you say to the argument that we just heard that, so there's a textual standard for when the president may call guardsmen into federal service. And as to the numbers, there's a textual commitment to the president's discretion on that. But as to the duration, the statute is just silent. So what would be the rule that we'd be applying?
Your Honor, I disagree that the statute is.
So I agree here with chasing stars. I want a podium pounder, but just for clarification, what he's standing at is actually called a lectern. That vertical thing you stand behind with like the little table and the microphone, that's a lectern. A podium is like a elevated platform that you might stand upon. They might place a lectern on it, but the podium is like the little elevated stage area. So what you want is a lectern pounder. The guy during January 6th who walked out with Nancy Pelosi's lectern, right? The famous photo of him with the lectern under his arm, that's a lectern.
Silent. I do think the text structure and the analysis in this court's stay opinion, especially when read in light of the background constitutional framework, does not support defendants' assertion that after the guard has been called up, they can remain in federal service indefinitely. And so as to the text, I think Your Honor pointed to the present tense in the text of Section 12406 is unable. The structure and the court's analysis in its stay opinion emphasized that Section 12406 is designed to address extreme exigencies akin to rebellions or invasions. I think it would be pretty extraordinary to suggest that this authority to call forth state personnel that are the founding era evidence makes quite clear that our framers expected state militia personnel to ordinarily be under control of the states, that some exigency can be invoked and then provide a basis for permanently or indefinitely keeping the guard under state control. And in terms of the standard, I think the court could look to the same standard it looks to in deciding whether Section 12406 is satisfied.
Okay. Counsel, is that question before us with regard to the federal government's appeal? Is anything before us other than was the original order, can it stand? I mean, are extensions or the law relating to extensions or facts that occur on the ground after the district court issued the order that was appealed, are any of those issues actually before us in this appeal?
Not in the appeal of the district court's original injunction. Of course, they're at issue in the pending motion to vacate the stay that we filed a couple of weeks ago. But I will say the legal issue about the nature of the circumstances that justify invoking Section 12406 does have a direct connection to this argument that you've heard on the other side about whether there's a time limit under the statute, because in recognizing that the statutory criteria require a showing of extreme exigent circumstances akin to a rebellion or an invasion, I think it naturally follows from that the federalization cannot just be indefinite in duration. It's designed to address extreme circumstances under Section 12406(3), where the regular forces, which we understand to mean federal civilian personnel, are unable to respond to the emergency.
By the way, the Oregon judge, Immelgut, who issued a TRO against Trump calling out the Oregon National Guard and then calling out the California National Guard and sending them to Portland, her definition of ordinary forces was even more constrained than this guy. This guy is at least limiting it to the civilian federal law enforcement like ICE, Customs and Border, Federal Protective Services. Judge Immelgut, a Biden-appointed judge who was raised to the bench after Trump was reelected, but before Trump was sworn in. Judge Immelgut said, no, the regular forces means the professional full-time military. So under that reading, Trump would not be authorized to deploy the National Guard unless first the full-time professional military, Army, Navy, Air Force, Marines, Coast Guard, and Space Force had all failed to put down the problem. Then you can call out the part-timers, the National Guard. No offense to the National Guard, but you understand what I mean.
So, counsel, I'm not certain that those issues are before us, but let's assume for the sake of argument that they are. So would it be your view that, let's say, that a court determined in the face of legal action that the president's initial call up under subsection 3 were justified. Is it California's view that as a theoretical matter, California could come back to the district court every day and say, you found that it was justified on September 1st, but we're now at September 4th and it's no longer justified. And if you lose on September 4th, we're now at September 7th and it's no longer justified?
Yeah, so to what extent now we're asking the federal judiciary to micromanage the commander-in-chief's deployment of the National Guard for federal service? What competence, even assuming the judges had the constitutional authority to do that, which they do not, what competence? They were not chosen for their military acumen.
No, Your Honor, we don't take that extreme view. We don't think the
So
statute.
tell me what your view would be as to if there were a finding that it were initially justified, and your view is that it is justiciable and can be determined at some point as to whether it's continuing, the justification continues, how often could the court get involved?
Great
Your Honor,
point.
to step back, we think the appropriate approach here is to accord, an appropriate level of deference and discretion to the president in determining whether the exigent circumstances that justified the original federalization continue to exist. We acknowledge some need for flexibility on the part of defendants in this area, but I think there has to come a limit, and when it is no longer reasonable to conclude that the basis for the federalization continues to exist, and this gets back to your question, Judge Miller, about the standard courts could apply. I think you could apply a reasonable good.
And this is why Trump's lawyer should have been prefacing every remark with, even were this subject to review, which we believe it's not, this falls within the political branches of government, because this lawyer is making a reasonable point. We wouldn't want to live in a world where the president, any president, the next one might not be Trump, might be Kalama, can call out the National Guard forever, and American cities are simply under military siege for years at a time. There does need to be a limit. But the fact that there does need to be a limit does not address the question of who gets to decide. Again, it should be the political branches that make that decision. Congress, anytime Congress wants, they could put a time limit into 12406. They could say for 90 days, 180 days, 200 days, renewable of this, blah, 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 blah. They could put all that in there. That they haven't done so leaves it within the discretion of the commander-in-chief. And nothing puts it within the realm of the Article 3 judiciary.
Faith standard in asking whether the exigent circumstances that initially supported the federalization continue to exist. And in our view, the answer to that question is they no longer reasonably exist. And I realize I'm getting into some of the issues discussed in the motion to vacate rather than the appeal. But in our view, when you have the circumstances that existed on the ground in Los Angeles, on June 6th and 7th, they have not recurred. We've cited to declarations from state and local law enforcement officials as to conditions on the ground in Los Angeles. You also have defendants' own words and their own actions. They've repeatedly acknowledged that conditions on the ground have changed substantially, including the risk to federal personnel.
Sure, but they've calmed down because the National Guard has been deployed. It's like if you built a prison with no doors, and all the prisoners just walk out of the building, and you're like, oh my gosh, we can't have this. We better put locked doors on the prison. And so you put locked doors on the prison, and the prisoners no longer are able to walk away. You don't then turn around and say, well, now that the prisoners are no longer able to walk away, we can take the doors back off. And again, the fundamental question is, who gets to make the call whether the risk of a resurgence in violence, if the National Guard are pulled back, is real enough to maintain the National Guard presence? These are National Guard. They have day jobs. You're going to send them back. What happens if you send them all home and then 2 days later you have to call them back in again?
Los Angeles. And then most tellingly, I think, was the action of a couple of weeks ago where they professed an intent to send all 300 federalized California Guard troops 800 miles away to Portland, and then proceeded to send 215 of those 300 troops, and presumably would have sent the entire contingent if they had not been enjoined by the Federal District of Oregon. We think in those circumstances.
So, Counsel, let me ask you a question about something that definitely is not before us. Would, in California's view, the propriety of sending the California guardsmen or guardsmen and women to Portland be challengeable in front of Judge Breyer?
Your Honor, there's certainly a factual nexus to the case before Judge Breyer, but we have not and do not intend to challenge it in that court. We're moving forward.
Okay.
We've joined the suit in the District of Oregon.
Okay, thank you.